Is that the Narcoshan?
Right out of the gate, this case is already tangled, and if you're paying attention, you can feel the confusion building inside this courtroom. You've got multiple cases, missing discovery, and even the attorneys themselves aren't fully aligned on what's been filed and what hasn't. That's not just procedural noise, that's a serious issue. Discovery is the backbone of any criminal case. It's how both sides know what evidence exists, what's coming, and how to prepare. And here, one side is openly admitting they don't even have everything yet. Now think about what that means. If you don't have full discovery, you're essentially walking into court partially blind. That's dangerous for the defense, and it can also delay justice for everyone involved. And notice the strategy here. They're trying to align both exams on the same day. But yeah, that sounds efficient, but it's also a subtle way to buy time without saying it outright. This is where courtroom strategy starts showing. It's not always loud objections or dramatic arguments. It's these quiet procedural moves that shape the entire case before it even begins.
David I. Goldstein, I'm appearing on behalf of the defendant. Your Honor, I don't know if the paperwork in the new case is caught up yet, but I have substituted in on that file.
I think we only have him on one.
Correct.
Okay, but that's okay. We'll let him go ahead. All right.
Your Honor, I've had an opportunity to talk to Ms. Blanche in this matter. We think it'd be best to have both exams on the same day. The problem is, number one, not only do I not have the discovery in the second file yet, but she indicated there's some more discovery coming. On the most recent file, Ms. Blanche?
It's just the 911 call that I discovered it. I'm discovering it today. So that should be easy.
So if we ask you to set it for an exam, you're going to say, do I have all the discovery? And the answer is going to be no, I don't.
But the only thing that's missing is the 911.
Well, I have to get the file from the public defender, which I will have probably today or tomorrow, but I don't want to mislead the court.
Gotcha. All right. Well, why don't we adjourn it out, make sure everything's there.
I was for 2 weeks, Your Honor.
2 weeks.
But I do want to address the issue of bond, Your Honor.
Probable cause conference during October 31st, 2024, 9 a.m. As to bond.
Your Honor, on the older case, a bond was set and posted. I don't know if that bond was ever canceled. There's nothing that I was able to find. And I know that the magistrate, when she did the arraignment on the new file, wouldn't have had the authority to do that, I don't believe. So I'm going to address only the new case.
Oh, you're saying that one was not canceled. I think that one. Do you have the old cases posted?
I don't show it posted. But now I show it
On which one?
1402.
The original case, which is, I believe, a 14B case, he did post bond.
On 1402, bond was denied.
It was originally set at 25,000 cash surety, but I don't show it ever posted.
You did post it?
There was a hearing, an arraignment, a bond was ultimately denied.
That was on 1402.
Yeah.
What about on 13?
I'm sorry, I got the dates confused. I'm sorry, I got the dates mixed up, the case numbers mixed up.
No, it's okay.
I don't show bond posted, but I show 200,000 cash surety.
Okay. So I got 200 cash surety on the old one.
No, that's
Bond.
that's backwards, Your Honor.
You think it's backward?
Because I appeared at the arraignment on the older file.
This is where the case starts to unravel, and you can literally hear the confusion in real time. The numbers don't line up, the bonds don't match, and both sides are trying to reconstruct what actually happened. That's not just messy, it's dangerous. Bond history matters. A lot. Because it tells the court how the defendant has behaved under supervision. If a bond was posted and then violated, that's a major red flag. But here, they can't even clearly confirm which bond was active, which one was denied, or how the sequence played out. And look at the dynamic. The attorney is confidently saying it had to have been posted, while the court is saying, I don't see it. That's a direct conflict between assumption and record. And in court, records win every time. This is where cases can shift dramatically. If the court believes the defendant violated conditions after being released, the consequences get much harsher. But if there's uncertainty in the record, the defense has an opening. So the real question is this confusion just paperwork? Or is it the beginning of a bigger problem?
The magistrate set the bond at 25,000 cash or surety. It was posted because he got out of jail and then was charged with a new charge after he was released from jail. So it had to have been posted.
You're saying on which one?
Okay. On the old case.
Well, I'm going old by the case number, maybe.
Right, the 1360.
This is the older one. How'd that? Oh, because we're using their number.
Different case
That's
numbers,
why.
right.
Okay. So they're not sequential.
Correct.
And one's a one. So I have bond denied on the 14-1 case.
14B.
Bond denied on 14B case, the older one.
Yeah.
Did 2,000 on this.
I mean, it's possibly we don't have written the bond yet. But I don't show it. That's
Well, hold it. He couldn't. But how did his bond become denied? Because of the new case?
It looks like there was a bond violation.
I may be able to provide some clarity on 10/9/2024. He was arraigned on a new case, and he also was arraigned on a bond violation for his old case, and that's when the judge.
That's when, okay. Bond
denied
denied on the 14B matter because.
That's
Okay.
interesting, Your Honor, because I had an appearance in the file because I appeared at the arraignment. Nobody notified me about a bond violation hearing, and I wasn't present at that hearing.
Now, this is a serious issue, and it goes beyond strategy. The defense attorney is essentially saying, I wasn't notified. If that's true, that's not just inconvenient, that's a due process concern. In the legal system, representation matters. If an attorney is officially on record and a hearing happens without them being notified, it raises questions about fairness. Because how can a defendant be properly represented if their lawyer isn't even present? But here's the other side of it. The court isn't immediately validating that claim. Instead, it's trying to piece together what actually happened. Was there another attorney? Was it a public defender stepping in? Or was this a procedural breakdown? This is where courtroom reality hits hard. Systems aren't perfect. Notifications get missed, paperwork gets delayed, and sometimes, things slip through the cracks. But when they do, the consequences can be huge, especially in bond violation hearings, where decisions can directly impact someone's freedom. So now the tension isn't just about the case, it's about whether the process itself was handled correctly.
So he was denied counsel at that bond violation hearing.
So I think
Well, was it an arraignment on the bond violation?
I had defense counsel Nisker before David Goldstein, so I don't know.
I-
But I wrote.
What do you have?
Nisker caring for David Goldstein, that's what's in our notes. I wasn't there, obviously, but
No, he may have been a public defender, but he did not appear for me on that case. I was not notified of that.
it looks like he did have counsel with his name, not that Mr. Goldstein.
Well,
Correct.
no, I understand, and I appreciate it. But my point is that somebody just shows up and says, I'm his attorney when I've got an appearance in the file.
Well, I don't, but that would have been on the one that you're on.
Correct.
You're clearly on.
Right, correct. So my understanding, and I'm not questioning Ms. Blanche's notes, is I appear at the arraignment, magistrate sets a bond of 25,000 cash or surety. That bond was posted
I see it now.
because otherwise he wouldn't have been released from the jail and then been charged with a new charge the same
Have-
day.
But you have say that again?
Okay. We arraigned him on the 14B case.
Right.
Magistrate Fink set a bond,
Correct.
25,000 cash or surety. He posted
So he was out.
that, and he was out because the new charge occurred the same day.
Ah,
So he must have been released from the jail, or he couldn't have committed the new offense.
The new offense while he was incarcerated, though.
No,
The stalking?
the new offense was him allegedly going to the address where she told him not to go. She put a condition on his bond when I was there of no go-to, no contact. The new charge, as I understand it, I don't have the file yet, but my understanding is that that charge is he went to that location and had contact with the victim.
This is the turning point. Everything up until now has been confusion, paperwork, and procedure. But this is the substance of the case. The allegation is clear. The defendant went somewhere he was explicitly told not to go and made contact with the victim. That's not a minor technical violation. That's a direct breach of bond conditions. And in cases involving no contact orders, courts take this extremely seriously. Why? Because those conditions are put in place to protect someone. So when they're violated, the court doesn't just see it as disobedience, it sees it as potential risk. Now the defense is trying to frame it differently, suggesting he went there for a reason, possibly something harmless like retrieving belongings. But here's the problem. Intent doesn't always erase violation. If the condition says no contact or no go, then even a brief visit can trigger serious consequences. So the court is now shifting from confusion to clarity. The question isn't what happened with the paperwork anymore. It's did he violate a direct order? And if the answer is yes, everything changes.
So he must have been out of jail. Correct?
So I'm a bit unclear. So here's what I've got. I've got a bond denied on the other one, the 200,000 on the other.
Right, and that's the one I wanted to address, but I needed to know whether the old bond had been canceled, and apparently it was without me being notified.
But hold on. When did he post to see if he posted? Okay.
Friday. What else?
How did they post the bond? Was
With the
it,
bondsman, I believe.
is it a bond one? Because usually then I have something.
Yeah, Jacob.
Jacob,
Yeah.
family first bonding.
Jacob.
Family first bonding. So, okay, so what I have while we're waiting for that to come up is, right, so that's not it. So somewhere in here, October 4th. I have this listed as a bench warrant was issued for him, but I don't see the warrant on the old case.
Your Honor, Judge Fink indicated that he had to do certain things by 5 o'clock that day, or a bench warrant would issue.
Magistrate Fink?
Yes, and he did what she requested. So that's why the warrant was never issued.
I got. I don't know. Just go saying if that's the case, because what's this date? They recalled the warrant. And the only reason I'm saying that is the form that I'm looking at says that on the 8th of October, it says arraigned on bench warrant.
At this point, the timeline is starting to collapse under its own weight. You've got mentions of bench warrants, recalls, violations, all layered on top of each other, and the judge is clearly trying to reconstruct the sequence. This matters more than it seems. In criminal law, timing is everything. When did the violation occur? Was the defendant already in custody? Was the warrant active or recalled? Each of those details can completely change how the court interprets the situation. And notice how the judge says, "I've got a problem here." That's not casual language. That's a signal. It means the court doesn't have a clear, reliable narrative. And without that, making a fair ruling becomes difficult. But here's the reality. Even when things are unclear, the court still has to make decisions. And when there's uncertainty combined with possible violations, courts tend to err on the side of caution. So now the defense isn't just arguing facts, they're fighting against a growing perception that something went wrong, even if the details aren't perfectly clean.
On the bond.
On the bond violation.
It won't show, show. The bond is not created, so I don't-
Say again.
It won't show. The bond. Bond will be changed. People,
Okay, so I've got a problem here because you're saying I don't see the bond. We can't find it. That doesn't mean it didn't happen. But you're saying the events, he's saying he's out. You're saying the events that led to this, he was in.
Correct, but he also did PPO violation. So there was a PPO violation, he was picked up on that PPO violation, put it for that. He had a $25,000 bond on that PPO, and then while he was violated the PPO, he was in custody, and that's when this aggravated stalking occurred, because he starts contacting the victim, threatening her, telling her to drop the PPO. So that's what my notes indicate, that's what I have, that he actually was picked up on a PPO violation, got a $25,000 bond on that, and then this aggravated stalking happened while he was in custody for that.
Okay, so before anybody says anything, now that with this new thing, he's in on the 14B matter, 25,000.
Sure.
Hold on.
Okay.
He's in on that. He posts the bond on that, but is then picked up because of a PPO violation. There's another bond. I'm just going by what she says, Mr. Goldstein.
She's close.
The bond is then there's that bond, and then this occurs while he's on that. That's what you're telling me.
Yeah.
Okay, she's close, Your Honor. He was not actually, when he was arraigned on the 4th of October, he was not in custody. It was a Zoom arraignment.
On the 4th.
On the
That makes
4th.
sense.
Right. And the judge said a $25,000 cash or surety bond. She gave him till 5 o'clock. She said, you either post it by 5 o'clock, you report to the jail, or I'm going to have Judge Simpson issue a bench warrant.
This moment finally brings some structure to the chaos. The judge lays out a clear sequence: bond set, deadline given, and a warning issued. Post the bond or face a bench warrant. That's standard procedure. No ambiguity there. But what follows is where things get complicated. The defense claims the bond was posted, the defendant was released, and then the alleged violation happened afterward. If that's true, it creates a very specific narrative: release to violation to new charge. On the other hand, the prosecution's version suggests overlapping custody, violations, and continued misconduct. And those two versions don't just differ slightly, they completely change how the defendant is perceived. This is where credibility becomes everything. The court isn't just evaluating facts, it's evaluating whose version of events holds together under pressure. And here's the key takeaway: in situations like this, even small inconsistencies can tip the scale. Because if one part of the story doesn't add up, it makes the rest harder to trust. So now the case is no longer just about actions, it's about which narrative the court believes.
I don't know if she said Judge Simpson. She said, hey, the judge, okay? Okay, he did post. And then he went, allegedly, and this is my understanding of the new file, and I'll say to Ms. Blanche, I haven't seen that, so she can correct me. My understanding of the new charge is that he allegedly went on the 4th of October to the victim's house, which was a violation of the conditions that Magistrate Fink set. Okay, that's my understanding.
But then would have also been a violation if there was a PPO.
Right, that's
Which
correct.
then makes sense, is what Ms. Blanche is saying, that then he's picked up on the PPO and has that. Okay, having said all that, what do you want me to do?
Your Honor, first of all, I want to clarify whether the $25,000 bond that you can't find, that not only you personally, but that we can't find, is still in effect. Because he says he's paid a bondsman, and he said the bondsman posted.
The last order on that file is that his bond was denied on that. But I don't know why precisely. It would be customary that if there's a violation and they're brought in, his bond is, if there's an allegation of a bond violation, his bond would be denied pending a hearing, which would have to take place before me.
This is one of the most important legal clarifications in the entire hearing. The judge is laying out a fundamental rule. When there's an alleged bond violation, the court can deny bond temporarily, pending a proper hearing. That's not punishment, it's precaution. And this is where a lot of people misunderstand the system. Bond isn't a right in the sense that once you get it, it's permanent. It's conditional. The moment those conditions are allegedly violated, the court can pull that privilege back immediately to reassess the situation. Now, from the defense perspective, the frustration is obvious. They're arguing they weren't notified, that things happened without their involvement. But from the court's perspective, the focus is different. Given what I see right now, what is the safest and most reasonable position? And safety almost always outweighs uncertainty. So even if the paperwork is messy, even if the timeline isn't perfect, the existence of a violation allegation shifts the balance. The court doesn't need absolute certainty at this stage. It needs enough concern to justify holding the defendant until things are clarified. That's the reality of bond law. It's about risk management, not final judgment.
So your question as to whether or not it's in effect, I would say at this point, given what I see, his bond is actually denied because of the other allegations.
Right. And Judge, the only thing I'm saying, and I don't want to get off on a rant because this is not the only case where this happened. Defense counsel, other than public defenders, don't get notified of bond violations or community corrections violations, very rarely. So I'm not notified of a bond violation. I'm not notified of a bond violation hearing. And so I'm hearing all this from Ms. Blanche for the first time. I mean, it's not her obligation, but I'm just saying that I'm hearing it today for the first time. So I was not aware that the bond had been denied.
Okay, so that we're clear, and I don't know at what point it happened. I mean, I hear your point, but
I assume it happened when he was arraigned on the new charge, which I think was the 8th.
yes. And why that didn't happen, I do not know. I can't say. So,
Your
and
Honor,
I don't know that I can resolve it at this point.
okay, well, let me just address the issue of bond in general then. Okay, well, let's sort of start at the beginning. There's no allegation, my understanding, there's no allegation in these that there was any physical violence or physical, anything of that nature in these cases.
Can I just say
This was a
something?
situation where there was a PPO, allegedly there's a PPO.
Hang on one second.
Good.
We just got a confirmation from the jail that the surety was not posted.
Well, we'll have to contact the bondsman then and find out what's.
That's why I don't see it in their file.
Okay. Well, we'll, that's something we'll have to deal with the bondsman. But
Okay.
all right, anyway, Your Honor, the allegations are that he violated a PPO by having contact. With regard to the second case where the $200,000 bond is, my understanding again, and I haven't seen the discovery, but I did have a conversation with people involved in the case, is that he went there to get his, because he was told not to live there, not to stay there. He went there to pick up his clothing. Now, we know that there are civil standbys. You and I know that.
Now here comes the defense narrative, and it's a strategic one. They're reframing the entire situation, not as stalking, not as aggression, but as a simple, almost innocent act going to retrieve personal belongings. And on the surface, that sounds reasonable. Anyone could relate to that. But here's the legal problem. When there's a no contact or no-go condition, the reason doesn't always matter. The condition itself is absolute unless modified by the court. And the judge even hints at it. There are legal ways to handle situations like this, like a civil standby. That's where law enforcement supervises the retrieval of belongings to ensure no violation occurs. But the defense admits he didn't know about that. And that's critical. Because in court, I didn't know rarely erases responsibility. The expectation is that once conditions are set, you follow them strictly, or you ask for clarification through proper channels. So now the defense is trying to humanize the action, while the prosecution is emphasizing the violation. Two completely different lenses on the same event. Which one holds more weight? That's exactly what the judge is about to decide.
But he didn't know anything about a civil standby, so he figured he could go there.
Mr. Golston, I got a lot of folks I got to get out of here.
I know.
I don't mind hearing the bond motion, but typically if it's going to be a lengthy bond motion, I'll hear it at 3 o'clock because I can't have folks waiting.
I appreciate that, Your Honor. I can't, I'm in front of Judge Slade this afternoon, so I can't do it 3 o'clock. So, all right, anyway, Your Honor, I think the court understands my position.
I understand your position, but I think the first thing before I would even if I were to find that the bond was posted, or even if I said, okay, it shouldn't have been denied, whatever, the best information we have is the surety never posted the bond.
And that's something I can deal with, but yeah.
Okay, so
But Your Honor, what I was really addressing was the $200,000. I'm asking the court to reinstate the bond in the original case, the old case, and reduce the $200,000 bond to something much more reasonable, given the fact that I don't believe there's any allegations of any injuries or any threats, that he went there strictly for the purpose of getting his clothes.
Is there a brief response then?
Just brief, there are threats. It's not that great stalking. Calling her from jail, telling her to drop the PPO, saying really terrible things to her. So he violated his PPO, gets a new charge, and then he's still contacting her and being aggressive with her. So I think that the bond, $200,000, since he was given a chance at having a personal bond, is.
This is where the prosecution lands its strongest punch. It's no longer just about one alleged violation. It's about a pattern. Contact, threats, continued behavior even after charges are filed. That's a completely different level of concern, because in bond decisions, courts look at behavior trends, not isolated incidents. One mistake might be explainable, but repeated actions? That suggests disregard for court orders. And listen carefully, the prosecution uses phrases like threatening, aggressive, still contacting her. That language is intentional. It frames the defendant not as someone who made a mistake, but as someone who continues to pose a risk. At this point, the defense's earlier argument about just picking up clothes starts losing ground, because even if that explanation held initially, continued contact after that undermines it. This is where cases shift fast, not because of one dramatic moment, but because of cumulative behavior that paints a bigger picture. So now the judge isn't just evaluating an incident. The judge is evaluating risk going forward.
Here's what I'll do. Get the discovery, Mr. Goldstein, take a look at it, and then I'll hear argument on the bond on the 31st. That's the best I'm going to be able to do, because that way everybody can check whether or not this other bond was posted and whatever. If it's going to be a lengthy argument, I would ask that you let the court know so that we can set it at the 3 o'clock time.
It's fine, Your Honor. Thank you.
Thank you. Bond will continue at this time, October 31st. Court calls the case People versus James Buggy. Court calls the case People versus Golam Gambari.
Good morning, Assistant Public Defender Lauren Prenny on behalf of Mr. Gambari. Mr. Gambari, please state your name for the record.
Golam Gambari.
You know, we're here for a pretrial. Mr. Gambari also has a pending bond violation. I did get an updated report from Ms. Kerr today. Mr. Gambari is asking for an adjournment of the bond violation hearing. He did send out the test, and it did come back positive. However, he says around this time, he did a test at the hospital. He takes narcotics for his some medical conditions that are prescribed. They do drug testing consistently there to ensure that he is taking them in accordance with therapeutic processes. And he reports to me that he believes that test that was done at the hospital would come back negative. He just has not received those results yet.
When is that test?
He says that test was around the time of October 1st. Is that right?
Yes.
So is he indicating there was a test that came back that the cocaine is a false positive?
He is.
Really?
He's saying that he did not consume cocaine, and he believes this other test will show.
So when that test was sent out, it came back positive.
Yes, they sent it for a review.
They sent it for a review, and it came back positive for cocaine.
Now we shift into an entirely different case, but the tension doesn't drop. If anything, it spikes, because now we're dealing with drug test results, and the stakes are just as high. 2 tests, both positive for cocaine, and the defense is trying to counter that with a 3rd test that hasn't even been produced yet. This is a tough position to defend, because in court, evidence isn't about what might come, it's about what's already in front of the judge. And right now, the only confirmed evidence points in one direction. The defense tries to explain medical conditions, prescribed medications, possible confusion, but here's the problem. There's no medical justification for cocaine. That's why the judge immediately focuses on it. And then comes the claim, I didn't use. That's a direct denial against confirmed lab results. So now the court is faced with a credibility test. Do you trust the defendant's word or the documented evidence? And until that new test is actually presented, the answer is almost always going to favor the evidence.
Correct.
So now there's this other test that we're supposed to get, but we don't have the results that are going to show what?
He believes a different result than the test that was done at community
A
corrections.
different result, like no cocaine?
Correct. He denies, Your Honor, that he consumed any cocaine. He denies that he consumed any cocaine. He does have a list of medications that he also testified for opiates. He does have a list of medications that he provided both to community corrections and to me that do include prescriptions for opiates. I know the court is more concerned about the cocaine, as there's no medical reason to consume cocaine. But again, I can only report to the court that he maintains that he didn't use cocaine, and he wants to prove it to the court using this other blood test. We've spoken quite a bit about this, and he denies any use. He is asking that he not be remanded today. He again does want some more time. He has a eviction.
When was this blood test or this test at the hospital?
Oh, he was in the hospital around the time of October 1st. He has an after visit summary. He was at Trinity Health on October 1st at 10:30. On that date, he did testing. And saw his doctor for his medical needs.
And we don't have the test results back yet?
Yeah,
No.
When are they expected back?
just give it time. I can get it back.
He says he just needs time.
When are they expected back?
Do you know when they're coming back?
I can get it today, tomorrow.
Pardon?
I can get it today.
So you could have gotten it yesterday and then had it here.
I didn't know that. I have to bring it.
He says he will. But Your Honor, he does want me to tell you that he does have a hearing on his an eviction proceeding hearing today. He is concerned that he's going to be evicted if he is remanded at this time.
No lease. I have to sign in my new lease. No eviction.
Where do you live? Ann Arbor.
Yes. And I have to sign in my new lease. I don't have no eviction.
He doesn't have an eviction hearing
We have to sign.
because they do those on Tuesday.
Okay, I'm sorry.
Today's Wednesday.
I misunderstood. He has to sign his new lease
Yeah, I
today.
have to sign in a new lease. At the same time, I have to be on a court today at 2:30 for I'm victim and for the accident my damage my property.
Oh, okay, I'm sorry. He is the alleged victim on another case at 2:30 today
I'm the victim.
Where?
for damage to his property. Wednesday, 2:30 before Judge Garwood, Magistrate Garwood. It is a small claim.
It's a small claims. It's a civil action. Okay.
So, Your Honor, again, he's asking for an adjournment.
But he could have had his
For more
test
time.
results. If you want me to wait for, he could have had him here today because he just has to get them from the hospital. But he didn't do that. And then he comes here in court to say that I'm going to see this miracle test saying that the cocaine wasn't there when we've already had two tests that say that the cocaine was there. Have I summed that up correctly?
Your Honor, I don't know if, I don't want to, this is my assumption is that Mr. Gambari was waiting to hear the results back from the sent out tests. Ms. Kerr did send up, I called her this morning and she said, oh, I didn't realize I had the results back. So perhaps he was waiting for those results to come back before getting the other tests because
Oh,
he maintains that he doesn't know where the cocaine is from.
okay. People.
Your Honor, this is an open dry second offense.
I know.
First offense is from 2018, and it involves a crash to a building.
You should, counsel, sign a release for you so you can get the test from the hospital. But at this point, the defendant's bond is revoked, defendant remanded to the jail. I'll adjourn this hearing to November 6, 2024, 9 a.m.
I'll come see you the next meeting.
And just like that, the decision is made. Bond revoked. Defendant remanded. No delay, no hesitation. This is the court drawing a hard line. When you combine multiple positive drug tests, unverified claims of alternative results, and a lack of immediate supporting evidence, the risk becomes too high for release. The judge even points it out clearly. The defendant could have brought those test results today. He had the opportunity, but he didn't. And in court, missed opportunities matter. What we've seen across both of these cases is a consistent theme. Conditions matter, credibility matters, and timing matters. Whether it's violating bond conditions or failing to produce evidence when it counts, small decisions build into major consequences. The court isn't making emotional judgments, it's making risk-based decisions. And in both situations, where that risk was deemed too high. Now here's the bigger picture. These hearings aren't about proving guilt beyond a reasonable doubt. That comes later. These are about control, compliance, and whether the defendant can be trusted to follow the rules set by the court. And in both cases, that trust was shaken. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.